for those who are currently in process of joining. In the meantime, let me quickly share with you the anticipated agenda and information on our speakers. This event is a joint event of a U.S. consulate in Kazakhstan and EY offices dealing with U.S. inbound investments. Today we will be talking about investments and doing business in the United States in the current environment. Our speakers today will be Mr. Dean Matlack, U.S. Commercial Attaché Foreign Commercial at the U.S. Consulate General in Almaty, where he works to promote trade and investment relations with the United States. Previously, Dean served in the same capacity at U.S. embassies in Bangkok, Thailand, and Tokyo, Japan, as well as the U.S. Export Assistance Center in Minneapolis, Minnesota, helping U.S. firms identify and develop new overseas markets. He will open the event and introduce the Select USA program. The next speaker would be Alisa Karala, a U.S. Consular Section Chief. Alisa Karala has served as Chief of the Consular Section at U.S. Consulate General Almaty since August 2019. She joined the Department of State as a Foreign Service Officer in 2009. Her previous postings have included consular and economic work in India, Cuba, and Fiji. Prior to joining the Department of State, Ms. Karala worked as an English teacher in Mongolia and China. She will give us an overview of U.S. investment visas. Christian Kohler, Senior Manager at U.S. Tax Desk, EY Switzerland. After spending 6 years in the United States, Christian is leading U.S. inbound efforts in Europe, Middle East, India, and Africa, connecting businesses with the right resources and supporting clients making an educated business decision while entering or expanding the U.S. market. He will talk today about main business issues in the United States. Gillian Symes, Associate Partner on EY's U.S. Tax Desk. She's based in London. Gillian primarily advises private companies and family offices on U.S. cross-border taxes, both at the corporate and investor level. And Michael Peretz, EY Private Tax Desk Leader working from Zurich, Switzerland. Michael has been advising individuals and family enterprises on international aspects of U.S. taxation and multi-jurisdictional wealth planning for over 20 years. Gillian and Michael will focus on U.S. tax matters related to businesses and individuals investing into the United States, implications of U.S. tax residency. And my name is Vladimir Fisenko. I am a tax and law partner and head of people advisory services at EY Kazakhstan. I am with the firm for 16 plus years. Kazakhstan is my third country. I used to work in Moscow, New York offices of EY, the US CPA license, and have been practicing US taxes my entire career in EY so far. So for those of you just joining us, welcome. And finally, before we start, I'll give short answers to some of the most frequent questions. We will be running a live Q&A session at the end of the webinar. We have enabled our Ask a Question feature. It's on the right-hand side of your screen in the auditorium. So if you have any questions, just drop them in there. We will ask them later. And if you miss anything, don't worry. We will be sending around the feedback form with further possibility to download webinar presentation when it is available. Now I'm giving the floor to Dean Matlack, Foreign Commercial Service Officer at the United States Consulate General in Almaty. Dean, please start.
Thank you, Vladimir. It's a pleasure for us to partner with EY on this event, and let me begin by thanking all of our attendees. Before we hear from the experts, I'd like to make a brief presentation on why companies and entrepreneurs should consider the U.S. market for their investment. The United States is home to the world's most attractive consumer market, with annual GDP over 20 trillion and a growing population. According to the OECD in 2019, U.S. families purchased 14 trillion in goods and services, more than a fourth of the entire world's household consumption. The United States also serves as a competitive export platform. No other country has a more streamlined exporting environment. The US is business friendly with a transparent, fair, and stable business environment. The Global Entrepreneurship Index ranks the United States #1 out of 137 countries for entrepreneurship. This is a direct reflection of the appeal of the US economy and how it enables businesses of any size to access a huge consumer base, employ a productive workforce, and take advantage of a culture that promotes innovation. The United States is a recognized leader in research and development and registers more international patents than any other country. Today's innovators are safeguarded by a robust intellectual property protection framework, while the innovators of tomorrow are nurtured at leading universities and startup incubators across the nation. As the third largest nation by geography, the United States is home to a vast and varied landscapes with abundant natural resources. Businesses operating in the United States are powered by independent, stable, and low-cost energy sources, a motivated and skilled workforce, and access to an expansive infrastructure network. US workers are among the most productive in the world. Their output per hour is more than 30% above the OECD member country average. The United States hosts the most developed, liquid, flexible, and efficient capital markets in the world. A wide range of funding sources, from banks and investment firms to venture capitalists and angel investors, enable innovation and expansion, giving companies in the United States an important advantage. And now I would like to talk briefly about an upcoming conference for international investors. The Select USA Investment Summit is an annual event where international investors can learn about doing business and investing in the United States. Normally held in Washington, D.C., this year's investment summit will be virtual. More than 100 virtual exhibitors will showcase investment opportunities from every corner of the United States. High-profile business and government leaders will share insights on the latest business and investment policies and trends. The summit's networking tool helps participants set up virtual meetings with key attendees. So if you're keen to launch your business in New York or California, for example, you can make virtual appointments with state economic development and investment professionals that will walk you through the process and explore available investment incentives. Select USA Tech is a special program at the summit designed for international early stage and startup tech companies interested in building their business in the United States. At the Tech Forum, participants are invited to exhibit their product or service by including a promotional video on their exhibitor profile. Participants can also apply to pitch in front of a panel of venture capitalists and representatives from startup ecosystems across the United States. There will also be tailored workshops focused on pitching, scaling, fundraising, and financing their startups, including sessions on investment opportunities in emerging technologies. Another program at this year's summit is the Global Women in Tech, a new effort specifically for female entrepreneurs. The program will include mentorship, networking, and workshops highlighting lessons learned by international female founders who have successfully expanded their business into the United States. Now here's a snapshot of the most recent investment summit in 2019. The event attracted more than 1,200 international participants from more than 75 markets. If you are interested in attending this year's summit, please contact my office. In closing, let me just say that the USA is incredibly diverse, with the world's most attractive consumer market, a thriving culture of innovation, and one of the most productive workforces in the world. Companies of all sizes, from startups to multinationals, can find the ideas, resources, and market they need to be successful. Today, we have a great lineup of experts to speak to you about everything from investment visas to current investment trends, factors, and planning considerations for your successful investment into the United States. I hope you enjoyed today's program. Thank you very much. And back to you now, Vladimir.
Thank you, Dean. If anyone has any questions about the Select USA Investment Summit, please post them to our chat so that we could answer them later. And our next speaker is Alisa Caralla, U.S. Consular Section Chief. Alisa Caralla has served as Chief of the Consular Section at the United States Consulate General Almaty since 2019. She will give us an overview of U.S. investment visas. Alisa, welcome.
Thank you, and good afternoon, everyone. As mentioned, today I'm going to talk about the different visa programs that are available for foreign citizens interested in investing in the United States. So there are two main types of investor visas that we offer, the E category of non-immigrant visas, as well as EB-5 immigrant visas. Now, both types of investor visas have different features to consider. For example, the initial investment amount may be lower for an E non-immigrant visa. In fact, there is no set minimum requirement. The investment amount is going to depend on the requirements of your business. In addition, there is a three-step process to applying for an EB-5 visa, while an E non-immigrant visa application can be filed directly at your nearest U.S. embassy or consulate abroad. And finally, by definition, an E visa is for non-immigrants, meaning that it is intended to be temporary, granting stays of up to 2 years, while an EB-5 visa will lead to permanent residency. I'm going to start off by talking about the E category non-immigrant visas. So it's important to keep in mind that many preliminary activities to set up a business in the United States can be done with a B1, B2 visa, which is granted for business and tourism purposes. Some things that you could do would be to sign contracts, view different types of property, engage in business meetings, and the like. And many established companies use other temporary employment visas, such as H&L visas, in order to bring employees to work in the United States. This process requires that the U.S. enterprise file a work petition and a labor certification with the Department of Homeland Security, or DHS, and the Department of Labor before the employee may apply for a visa. But on the other hand, e-visas do not require filing this paperwork. The visas are processed entirely abroad. So what is an e-visa? It is a non-immigrant visa for citizens of a country with which the United States has a bilateral friendship or investment treaty in place. We're traveling for one of two purposes, to either conduct substantial trade between the United States and their home country, an E1 visa, or to develop and direct the operations of a business enterprise that the applicant has vested a substantial amount of capital in, or an E2 visa. An E2 visa is by far the most popular category, so I'm only going to speak about E1 visas just briefly. So the requirements for an E1 visa for traders include a qualifying treaty must exist between the United States and the home country. And yes, there is a treaty in place with Kazakhstan. So the treaty trader must, whether an individual or a business, possess the nationality of the treaty country. And how do we determine what nationality a business has? So to help you determine whether you or your business would qualify, you can think about these questions. Regardless of where your business was incorporated, do those who own 50% or more of the stock of the company have the nationality of the same treaty country? Or for smaller companies, do those who own the principal amount nationality of the treaty country? So the firm must be engaged in international commercial trade, and the trade volume must be substantial. But there is no hard definition of substantial. For example, a bottle cap trader could qualify on the basis of many small monthly trades, even when each individual trade represents a low dollar figure. On the other hand, a specialized fuel cell trader may make only a few trades per year, but these trades represent a significant amount of capital. To be substantial, there should be a continuous flow of transactions over time. one large transaction by its own is not sufficient to be considered substantial. Now, more than 50% of the company's international trade must be between the United States and the country of which the applicant is a citizen. And if the visa applicant is an employee as opposed to an owner, the applicant must either be an executive or possess highly specialized skills essential to the firm. And finally, the applicant must intend to depart the United States when his or her status terminates. Shifting to E2 visas, these are known as treaty investor visas. So again, a qualifying treaty must be in place between the United States and the home country, and the individual or business must possess that nationality of that country. The applicant must have already invested or be in the process of investing. Now, in the process of investing means that the investor must be close to the actual start of business operations, not simply signing contracts or looking for a property. Having the intent to invest or possession of uncommitted funds in a bank account is not sufficient. The funds must be already committed to the investment, and that commitment must be irrevocable. The enterprise must be real and operating, and the applicant's investment must be sufficient to ensure successful operations of the enterprise. Now, the investment must not be marginal. This means that it must generate significantly more income than just enough to provide for the investor and the investor's family member. It must have a significant economic impact in the United States. And the applicant must be in a position to develop and direct the enterprise. That means that he or she has control over the funds and the investment has been put at risk. Or if they're not the principal investor, the applicant must be employed as a supervisor, an executive, or as the possessor of highly specialized skills. And we will talk about that more in the next slide. And finally, again, the applicant must demonstrate intent to depart the United States when his or her status terminates. So taking a deeper look at employees. In order to bring an employee into the United States, the employer must already be maintaining e-visa status in the United States. That means the employer cannot be in the US on a B1, B2 business visa, for example, and then try to bring in an employee on an e-visa. The employee does not need to personally invest into the company, but the employer must have already made a qualifying investment in the United States. Now, there are two types of employees who may qualify: executives or supervisors, and essential employees. So for essential employees, they must possess special qualifications. Those are skills that make the employee's services essential to the company. And there are several qualities that could meet this requirement. These may include things like the degree of expertise in the employee's area of operations, whether other people possess the employee's specific skill set, the salary that these qualifications can command, and whether these qualifications are readily available in the United States. So it's important to keep in mind that knowledge of a foreign language and culture by itself does not meet this requirement, and that in some cases, a skill that might be considered essential at one point in time may become commonplace later on and therefore not qualify in the future. Okay, so what does the application process involve? The applicant must complete the required visa forms and provide evidence that the investment meets the requirements of the law. The applicant must provide proof of nationality, proof of ownership of the company, provide evidence of trade and evidence of a real and operating enterprise. And these can include anything from purchase orders, custom declarations, letters of credit, sales tax receipts, utility bills, invoices from suppliers, and so on. So e-visa holders will be allowed a maximum initial stay of up to 2 years, although the visa holder may apply for an extension of stay or a visa renewal for an additional 2 years. And spouses and children may accompany the primary visa holder, and they are not required to have the same nationality. Children must be under age 21 and unmarried. The spouse may also apply for a work permit, but only after entry into the United States. When applying for your visa, supporting documents must be submitted at least 10 business days before your interview date to allow time for review. Family members may apply together, or the spouse and children may apply later on separately. The typical processing time is 2 business days following approval of the visa. Okay, so turning to the EB-5 immigrant visa program, applying for an EB-5 visa, as I mentioned earlier, is a 3-step process. It involves both the Department of Homeland Security, or DHS, and the Department of State. From DHS, USCIS administers the overall investment program, while the Department of State issues immigrant visas abroad. Under this program, investors must make an investment in a commercial enterprise which creates employment for at least 10 full-time workers. The investment could involve creating an entirely new business, restructuring an existing business, or substantially expanding a business. For a new commercial enterprise, including one that results from the restructuring of a current business, the capital must create at least 10 full-time positions for qualifying employees. For the purchase of a troubled business, the investor can rely on job maintenance for at least 2 years. A qualifying employee includes U.S. citizens, permanent residents, and other immigrants authorized to work in the United States. It does not include the actual investor, his or her family members, or any foreign citizen in a non-immigrant status, even those who may have a temporary employment visa. So the minimum investment amount is $900,000 US in a targeted employee area. That means either a rural area or one with a high unemployment rate, excuse me. And the minimum amount in all other areas is $1.8 million. Now, these amounts are determined by DHS and they are subject to change. So as mentioned before, the 3-step process to apply for an EB-5 visa. So first, you file an immigrant investor petition with USCIS. Now, the USCIS review period may last for up to a year, depending on their current caseload. Once USCIS approves the petition, they will send your case to the Department of State for visa processing. If your visa is approved, you will be granted conditional resident status in the United States for a 2-year period. And at the end of that 2-year period, you will file another set of paperwork with USCIS to be granted full permanent residency, meaning that you and your family can continue to live in the United States for the rest of your lives. And you can visit uscis.gov for more detailed information about the process and about the current fee requirements. And finally, here are some other resources for more information about these programs. Thank you very much.
Thank you, Alisa. Now we are aware of all options we have to obtain US investment visas. If you still have any questions or wish Alisa to answer your specific question, please drop it to the chat. Alisa will pick it up later. Our next speaker is Christian Kohler, Senior Manager at EY US Tax Desk based in Switzerland. After spending 6 years in the United States, Christian is leading US inbound efforts in Europe, Middle East, India, and Africa, connecting businesses with the resources and supporting client educated business decision while entering or expanding in the US market. Christian will cover following topics: overview of the main business issues faced by investors and companies, and understanding the key factors that can make a US investment successful. Go ahead, Christian.
Thank you very much, Vladimir, and good morning, good afternoon from my side as well. We appreciate your time and we're looking forward to the webcast and provide you additional insights. Uncertain times. As of August 2020, our EY Quest, which is the short form for our EY Quantitative Economics and Statistics team, published in their economic update that besides recent concerns over a resurgence of COVID-19, recovery is continuing in the United States, with the worst of the economic crisis likely occurring in April 2020. In August 2020, the US unemployment rate dropped to 10.2% in July from 11.1% in June and 13.3% in May, and its peak of 14.7% in April, which is really unheard and unseen. And the industry hardest hit with unemployment was the leisure and hospitality sector. The projected economic growth rate for the US gross domestic product was still estimated to be -8% for 2020, back in August 2020. And for 2021, we estimated that 4.5% will be the GDP. Considering a projected negative GDP rate of 10.2% for the European area and an overall projected GDP growth rate of -4.9 for the world. So at that time, we were still optimistic. And certainly the CARES Act, so the Coronavirus Aid, Relief and Economic Security Act, passed by US Congress in March 2020, which was approximately 2.2 trillion stimulus act, supported many companies and individuals. But with the resurgence of the virus by the end of 2020, we then again observed a drop in US economy. As of November 2020, the economy had a strong third quarter and labor markets have continued their steady improvement since April. The US Bureau of Economic Analysis estimated that the US real GDP increased by 33.1%, that's annualized, during the third quarter, following a decline of 31.4% during the second quarter and a decline of 5% during the first quarter. The projected US GDP rate for 2020 was -4.3%, and for 2021 was estimated to be down now to 3.1 from 4.5%. As of February 2021, the US economy gained 49,000 jobs in January, following the loss of 227,000 jobs in December 2020. The GDP growth rate for the US is estimated to be around 5.1% for 21 and 2.5% for 2022. The US economy showed overall improvement throughout the end of 2020, but is now facing headwinds due to the winter surge. The vaccines and the physical stimulus enacted in late December are providing support. And this Saturday, the House of Representatives of the United States Congress has approved a $1.9 trillion stimulus package proposed by the White House to alleviate the devastating economic effects of the coronavirus pandemic in the country, but whose result in the Senate, it seems, are still uncertain. Once in the Senate, Democrats anticipate a negotiation process with Republicans to amend certain aspects of the proposal. And once completed, they will send it back to the lower house for ratification. And we hope that these stimulus measures will provide a further boost to the US economy. With the US 2018 tax reform, and if we can move to the next slide. Yes, with the 2018 US tax reform, we've seen a trend of less FDI outflow from the US. US outflow FDI, so foreign direct investments, dropped from approximately 333 billion in 2014 to about 125 billion in 2019. Whereas, for example, in Japan, outflow of FDI increased during that time from 130 billion in 2014 to now about 240 billion. And besides COVID-19 and its impact on the US and global economy, there continue to be many reasons, as also Dean alluded, why entrepreneurs choose the United States as their investment location. The United States continue to be the #1 destination for foreign direct investments. The US is one of the most attractive consumers markets in the world, offering a wide variety, innovation culture, and the most productive workforce. Companies of all sizes, from startups to multinational, can find ideas, resources, and the market to succeed and grow. According to the US Department of State, Kazakhstan is the 81st largest trading partner of the United States with a total of $2 billion in two-way trade in 2019. US firms have invested tens of billions of dollars in Kazakhstan and concentrated in the oil and gas sector. For your reference on this slide, we listed the largest FDI sources along with the fastest growing sources of FDI as of 2019. The US has been relatively resilient, while other developed countries, especially the European Union, have seen a sharper decline. In 2019, as shown on the previous slide, the US attracted approximately 246 billion of foreign direct investments. If you are contemplating an investment in the US, I always share that the US is not just one country, but a country with 50 countries within, if we're looking at it with a tax lens. And Gillian and Michael will add more details and background later in our webcast, but even with the US federal tax reform, companies doing business in the US are still subject to many different state and local tax implications that vary by both taxing jurisdiction and by tax basis. In your site search and selection, some of the most important indirect tax implications to be considered and analyzed are, for example, sales and use tax, custom and duties, property taxes, excise, utility and insurance taxes, payroll taxes, business licenses, severances, or other business taxes. So in short, indirect tax represents the largest share of business tax outlays, so more than 70% of all business tax expenditures. I always use the example of property taxes in a site analysis and evaluation. For example, if you're negotiating a local property tax abatement, for example, for 5 years, what will be then the true cost of doing business in the location after the property tax abatement expires? And we see many US states adopting to the COVID-19 challenges and reassuring their commitments to economic development. Many US states and local communities are deploying new strategic growth initiatives, and we see many economic development agencies working closely together and US states streamlining economic development processes. US states continue to try to position themselves favorably by implementing new incentives legislations and across the US. At the same time, we observed that a competitive site selection remains important and an increased competition and additional due diligence needed in selected geographics. For some jurisdictions, job retention projects are receiving a higher level of scrutiny. If we look at the top states for foreign investments by investment totals in 2018 and the top 10 states by number of mobile project jobs created, we see that Texas, along with some of the Midwest and southeastern US states, continue to secure many FDI projects. Besides taxes, one of the most pressing and challenging aspects, and also besides COVID-19 and the increased unemployment rates, continues to be labor availability and labor cost. As previously mentioned, the industry sector that was hit hardest by the pandemic was the leisure and hospitality sector. And to identify the right talent at the right price is continuing to present a challenge for many of our clients. Also, operational costs can vary significantly across the US from locality to locality. And besides the federal incentive programs, such as, for example, new market tax credits or the opportunity zones, all 50 US states provide some form of incentives to encourage capital investment, job creation, and retention, as well as sustainability investments. Each jurisdiction sets its own program rules and requirements, so federal, state, and local. Each jurisdiction creates its own threshold for investment in jobs for issuing incentives. Some may offer incentives for investment with capital expenditures as low as $5 million. Others may start at 50 million. Important to understand is that certain discretionary incentives are only available if pursued prior to the announcement of a location or expansion of the business. And creating a holistic incentive strategy can increase the return on investment by an average of 5 to 25% of your capital spent. On this slide, we're trying to capture some of the questions you as a potential foreign direct investor will have to think through. What are key priorities for you as a company? Which cities and states should I consider for my investment? And which location criteria should I apply to compare them? What do you look for in a site? So should it be proximity to an international airport? Will be there a port of importance? What is the process for comparing locations? What are the key criteria for your site selection or site search? What is the most important aspect to your company during the site selection? So we have many companies, for example, that want to relocate at the US East Coast because the time difference is less than, for example, relocating to the US West Coast. And also, how do you factor in the needs of your current or new employees? Do you need to relocate your current employees? And if you do all the employees gonna join you to the new location, or do you have to find additional talent? And do I find the right talent for your business in the new location? In closing, I would say that the US presents great opportunities for companies and investors. But certainly there are also risks associated with an investment or expansion. And giving yourselves time to investigate your site search, site selection, the cost modeling, and the site comparison is important. I also advise my clients it's good to invest time upfront and lay a solid foundation prior to start building your new home in the US. Having a rocky foundation might be costly in the long run. And also in regard to what Dean mentioned with Select USA, I personally participated in 4 Select USA events, and I'm curious to see how the first virtual event will take place this year. And I do encourage you, if you are interested and you are contemplating an investment in the US, Select USA is providing a great opportunity to learn more about the US. And I am now passing on the floor to Michael. Thank you. Michael?
Thank you, Christian. As far as I could understand, despite all the stimulus help in the United States, there is still place for investment into the US, right? From Kazakhstan. As usual, certainly. If you have any questions to Christian, please leave them in the chat. And our next speakers are Michael and Gillian. Michael is our US private client tax leader based in Zurich, Switzerland. Has been advising individuals and family enterprises on international aspects of US taxation and multi-jurisdictional wealth planning for over 20 years. And Gillian is the associate partner in UI US tax desk based in London. So their topics are key tax issues for businesses expanding into the United States and individuals investing into the United States, and aspects of US tax residency implications and planning considerations. The floor is yours, Gillian and Michael.
Thank you, Vladimir. So as you can see, there are incredible amount of opportunities available for foreign investment and businesses in the US. But to emphasize the point made by my colleague Christian earlier, it's important to build, an appropriate foundation before jumping into, expansion to the US or into investments into the US or relocating there. Because, taking advantage of some of these opportunities may often result in some US tax exposure. So it's important to understand that before jumping in. So this part of our discussion will cover potential U.S. federal income tax and the state and gift tax exposure, and touch on state and local taxes, as well as some indirect taxes. If you could change the slide, thank you. So who or what is exposed to U.S. taxation? On the one side, you have U.S. persons. This includes individuals who are U.S. citizens or tax resident in the U.S. And we'll go over some of those rules. It also includes corporations and companies organized or incorporated in the United States, for example, a Delaware corporation. U.S. persons are taxed on their worldwide income. The federal income tax rate for corporations is currently 21%, and the federal income tax rates for individuals are applied on a gradual basis, but can get up to as high as 27%. On top of that, there are state and local governments that may impose an income tax on top of the federal rate. So it's important to keep that in mind. On the other side, you have non-US persons, right? Who are only subject to US income taxation on income treated as coming from US sources. This includes income derived from active trader business activities in the United States, which we often refer to as income effectively connected to a US trader business, or ECI. And the second category of income also subject to tax in the hands of non-US persons is US source fixed determinable annual or periodic income, or effectively passive income such as dividends, interest, rents, and royalties coming from the US. But there are also some important exceptions which we'll discuss later on. And finally, in terms of capital gains on the sale of US assets, these are typically not subject to tax for non-US persons. However, one important exception to this is the gain on the sale of US real property interests. Next slide, please. So let's turn our focus to individuals. For individuals to know whether they're going to be taxed by the US on the worldwide income or only on the US source income, they will need to know whether they are a US income tax resident, right? So let's take a look at some of those rules. So first off, one important thing to keep in mind is that a US citizen, regardless as to where they actually reside, is going to be taxed as a US person on their worldwide income. To be clear, a person doesn't need to hold a valid passport, US passport, or have lived in the US for a certain amount of years in order to be treated as a US citizen. A person, for example, could have been born in the US and spent the rest of their entire lives in another country, but still be a US citizen and taxable on their worldwide income as a US person. That's very important to keep in mind. Okay, so once you know that you're not a US citizen, you can look to this flow chart here on this slide. And so the first question you would ask is whether you hold a green card or have lawful permanent residency status in the US. If the answer is yes, then you're going to be taxed as a US person, regardless as to where you currently live, unless you are a tax resident in another country with an income tax treaty with the United States. It can demonstrate that effectively you have closer ties to that other country. Okay, so let's say that you determine that you're not a US citizen and you don't hold a US green card. The other way you could be treated as a US income tax resident is on the basis of the number of days you are present in the United States. So you'll often hear 183 days as the magic number. And this is true. 183 days in the US is the threshold, but you need to not only count the number of days in the current year, you need to look back and count 1/3 of your days present in the United States in the prior year and 1/6 of the days present in the US in the year prior to that, right? So for example, if you want to know whether you'll be a US income tax resident for 2021, you need to count all the days present in the US in 2021, 1/3 of the days in 2020, and 1/6 of your days in the US in 2019. If the sum of that exceeds 183 days, you'll be treated as a US person and subject to tax on your worldwide income. Unless, of course, you fall within one of a handful of exceptions. Some of these exceptions include days spent in the US on a valid student or teacher visa, as a diplomat. Might be possible also to exclude days spent in the US for medical reasons where you can't physically leave the US because of a medical situation. And in some cases, you can also fall within an exception referred to as the closer connection exception, where if you don't spend, using the formula, if the total is 183 days, but if in the current year it's less than 183 days, and you can demonstrate that you have a closer connection to another country, you might not be treated as a U.S. person for that year. Okay, so next slide, please. So we've touched on some of the differences on how a U.S. person is taxed versus a non-U.S. person. This slide here provides a little bit more detail. You'll note that some types of income are taxed differently or at different rates. For example, dividends paid to a U.S. person by to a non-U.S. person by a foreign corporation or U.S. corporation. I'm sorry, dividends paid to a U.S. person by a U.S. corporation or a foreign corporation under a U.S. treaty is taxed at rates of up to 20%. This category of qualified dividends. So that's important to keep in mind, which is much lower than the rates that can go up to 37% with other types of income. The same is true for the tax rate that's applied for gains on the sale of assets held for more than a year, long-term capital gains. That too is taxed at the reduced 20% rate. For non-U.S. persons, passive U.S. source income is taxed at a flat 30% rate unless an applicable treaty applies. And I believe the U.S.-Kazakhstan treaty applies a 15% withholding tax in lieu of the 30%. And income derived from trade or business activities in the U.S. is taxed on a net basis at tax rates that are generally applicable to U.S. persons. Next slide, please. So in addition to U.S. income tax exposure, one also needs to consider potential exposure to U.S. wealth transfer taxes, which are taxes imposed on gratuitous transfers of property. Right? And so this includes an estate tax, which is similar, a little bit different, but similar to an inheritance tax, a gift tax, and a generation skipping transfer tax, which we won't cover today. Importantly, U.S. income tax, the U.S. income tax residency test we just discussed does not apply for purposes of determining whether an individual is a U.S. person for U.S. Estate and gift tax purposes. Here again, a U.S. citizen is going to be subject to estate and gift taxes on the worldwide assets. But for a non-citizen, the test now turns to their quote-unquote domicile, right? And so for these purposes, a U.S. person acquires a U.S. domicile by residing in the U.S. and having no present intention of leaving to reside someplace else. For example, if you were to, pack your bags and relocate to the U.S., never looking back, with no intention of returning to Kazakhstan, for example, you would likely be treated as having a U.S. domicile for these purposes once you've landed in the U.S. If, however, you move to the U.S. for a 3-year work assignment and intend to return to your home country after the assignment ends, you would be treated as you would not be treated as having a U.S. domicile. Unless, for example, your intentions change through the course of your assignment and you decide to reside there on a more permanent basis. So, so this might lead to situations where, you might be taxed as a U.S. person for income tax purposes, but not for estate and gift tax purposes. The tricky thing about the domicile test is that it's subjective. It's not a strict day count test like it is for the under the income tax rules, and it's based on an individual's intentions, which can often be difficult to determine and pin down. So this is just an important thing to keep in mind. Next slide, please. So let's look at specifically the estate tax. The estate tax is a tax imposed at rates of up to 40% on the value of a deceased person's estate or patrimony or their legacy. U.S. persons are taxed on their worldwide assets, but have an exemption amount which they can also apply to lifetime gifts or against their estate of $11.7 million, and that's indexed for inflation. Non-U.S. persons, on the other hand, do not have the benefit of this $11.7 million exemption. Their exemption is only $60,000, but they're only subject to estate tax on their U.S. situs assets. And so these U.S. assets include U.S. real property interests, tangible property located in the U.S., stocks issued by U.S. corporations, which is important to note because it's often overlooked, and debt issued by U.S. persons, with the exception of portfolio debt, such as corporate bonds. Importantly, U.S. assets for these purposes does not include cash deposits at U.S. banks or U.S. Treasury bonds. Next slide. The gift tax applies to gifts made by persons during their lifetime. Two important things to note here are that intangible assets, such as shares in U.S. corporations, are not treated as U.S. situs assets for gift tax purposes, even though they are for estate tax purposes. And there is no exemption amount available other than a $15,000 annual exclusion amount that's available for non-U.S. persons making gifts of U.S. assets. Next slide. So this slide here illustrates and compares how a non-U.S. person might be taxed on different types of financial investments in the U.S. For example, as we've noted, cash deposits and bond interest are not going to be subject to a withholding tax, and they're also not going to be subject to estate tax. Conversely, an interest in a U.S. corporation, so U.S. shares, are going to be subject to U.S. estate tax, and there is a withholding tax applied on dividends paid. Next slide. So let's turn quickly to a couple of examples on how the estate tax might work in a few different scenarios. So if a non-U.S. person invests directly into a U.S. asset, such as, for simplicity's sake, let's say it's U.S. real estate, and they were to pass away while holding that U.S. investment, say it's $1 million, that value minus the $60,000 exemption is going to be subject to a 40% estate tax. The same is true if it were $1 million worth of Google shares. Okay. Now, next slide. Now, if instead they took their $1 million and said, you know what, I no longer need this $1 million for myself. I want to preserve this for future generations, and establish a trust or a foundation to benefit my family. Using an irrevocable trust can serve as protection against U.S. estate tax exposure. So here it doesn't matter whether the trust is a U.S. trust, it could be a trust established in the U.S. with a U.S. trustee, or it can be established outside of the U.S. as well. The key factors here are that if a trust is used, the settlor, the person who transfers assets into the trust, cannot revoke the trust or terminate it on their own. And they can't retain an interest in the trust as well. It really needs to be an asset that's set aside for somebody else, for family members. If that can be accomplished, there's a good chance that any U.S. assets held in that structure are not going to be subject to estate tax on the death of the person who established the trust. Next slide. Similarly, if an investment is made into the U.S. is made by a non-U.S. corporation, and that non-U.S. corporation is owned by a non-U.S. shareholder, when the non-U.S. shareholder passes away, there shouldn't be any estate tax due by virtue of the underlying investment being U.S. real estate, for example. However, there are some important caveats here. Formalities of the corporate structure must be respected. So, the shareholders cannot treat the assets of the foreign corporation as their own. And, preferably the corporation serves some other, commercial purpose other than, pure tax mitigation, right? So it needs to serve as a means of protecting against liability, as a joint venture vehicle, or something along those lines, for it to really serve as a tax planning opportunity. So in sum, individuals need to carefully weigh the potential U.S. tax implications before jumping into U.S. investments or relocating to the U.S. or even spending more time into the U.S. So now Jillian will cover tax issues relevant to corporations. Thank you.
Thanks, Michael. So what I want to talk about today is if you're a company and you're intending to expand your business into the U.S., what corporate issues potentially be faced. So as Michael noted, if you're a U.S. company, or if you're, for example, a Kazakh company that's operating in the U.S., the corporate rate of tax is going to be 21%, and that's both for ordinary income and capital gain income. We also levy state and local income taxes. So as Christian mentioned, you need to think about the U.S. as the United States from a federal tax perspective, but also effectively almost like 50 different countries, because each state has its own rules, which we'll talk about in a few minutes as well. So in addition to corporate income taxes, you may also have state and local income taxes. These vary by state from 0 to 13%, and you also get a deduction against your federal taxes. So if you're trying to estimate what your overall U.S. corporate tax liability might be, 25% rate tends to be a good ballpark tax rate for income tax purposes. As Michael noted, we also, in the corporate context, levy this withholding tax, this 30% withholding tax against your FDAP income. Again, that's dividends, interest, rents, royalties. So if your U.S. company was making a dividend back to the Kazakh home office, the starting rate would be a 30% of that gross payment, but that can be reduced under the treaty. If we're looking at the US-Kazakh treaty, that's probably going to be 5 or 15%, depending on a number of factors. So in addition to dividend, interest, rent, and royalty withholding, we also have something called branch profits tax, which will make a bit more sense on the next slide. So what this is if you say, well, I'm going to open up an office in the US. If I set up a corporation and that corporation pays dividends back to the home office, I'm going to suffer withholding tax. So instead, I'll operate in the US via a branch. Well, what that branch profits tax aims to do is to level the playing field. So you get equity of treatment between operating in the US via a branch or operating in the US via a US corporation. So overall, 21% corporate tax rate plus state and local taxes. And then we also need to make sure we're thinking about any withholding taxes that could apply. And if so, how do we reduce those? Okay, next page. So I've got 3 different options here of how you could structure your US operation. So let's say you were going to set up an office in the US or a production facility. How do you go about structuring that US entity? I've got 3 options on here. Representative office, which we don't tend to see a whole lot of. It's very, very minimal activities that you can do in the US to be considered a representative office. So for example, if you're in the US on a temporary basis, just trying to do some market business, that might be a US representative office. Again, very, very limited activities can happen in the US. The good thing about the US representative office is that you don't generally trigger a US tax liability. But again, these are very limited activities. What we tend to see more if you're actually going to be expanding into the US, expanding your business, is either a US branch or a US corporate subsidiary. I tend to favor US corporate subsidiaries if you know you're going to have people or property in the US. So for example, if you were going to set up a small US sales office, we generally recommend that you also set up a US corporate subsidiary, as it tends to be a bit easier to manage those intercompany transactions between your Kazakh home office or any other non-US office and your US office. So if we do set up a US corporate subsidiary, that can be either a US Inc., a US corporation, sometimes referred to as a C corporation, or you could set up what's called a US limited liability company, an LLC, and you need to make certain tax elections to treat that as a corporation. If you set up a US corporation, there's no restrictions with respect to what that US corporate office can do. But what we'd strongly recommend is that you make sure you understand how that US office is interacting with your other worldwide offices. So for example, your Kazakh home office or any other non-US office, and make sure you apply what we call US transfer pricing arm's length principles to any of those intercompany transactions. It's really important, especially when you're investing into the US and expanding into the US for the first time, to think about these things in the beginning rather than when, let's say, the tax authorities come and start asking some questions. So it's very much a manageable, it's complicated, but very manageable if you think about it and you structure into it using foresight rather than hindsight. As I said, 21% corporate tax rate, and then also any dividends. So if you've started your home office or your US office or your US production facility, and that US entity starts making money and you want to repatriate that cash back to, let's say, Kazakhstan, you need to think about dividend withholding taxes. And again, if it is held directly by your Kazakh home office, you're probably looking at a 5 or 15% dividend withholding tax rate. And lastly, and this is a topic I want to spend a little bit of time on today, state and local taxation. Again, 50 different states, 50 different sets of rules. When I'm working with companies, and I work with a lot of companies who are expanding into the US for the first time, I find that the federal tax issues you might face seem to be quite straightforward, and it's quite easy to get your head round what exactly it is you need to think about. But state and local taxes can be quite complicated. Again, if you're thinking about it as you expand into the U.S. in the first instance, it tends to be much more manageable rather than thinking about it when, let's say, one of the states comes asking some questions. Next slide, Christian. So there's a number of different state and local taxes that can be levied. And again, it depends on the states in which you're doing business. I'm going to focus mostly on income taxes on the top left, and then also sales and use taxes. But again, there's a number of different state and local taxes that you might need to think about. States calculate your tax liability in different ways. They also can potentially levy property taxes if you own land or buildings in a particular state, employment taxes, certain transfer taxes. It's a lot to think about. But again, if you think about it in the beginning, it tends to be a bit more helpful. So I'm going to focus on income taxes first, and then briefly discuss sales and use taxes. So income taxes. I often get when companies are first going to expand into the US, they'll come to me and say, which state should I organize my US subsidiary in that'll give me the best tax answer? And unfortunately, it's not quite that simple. So if you were to organize a US subsidiary, let's say in the state of Delaware, which is quite a common state to organize in, it's not just because you've organized that entity in Delaware, that doesn't mean only Delaware state taxes apply. States have what they call state tax nexus rules, which basically means if you've got a connection with a state, then you could have a state income tax liability in potentially all 50 states. So how do you create state tax nexus? State tax nexus is created generally by having people or property in a particular state. So for example, if you organized a Delaware subsidiary, you didn't have anything in Delaware, no people or property in Delaware. If you had an office, let's say in New York and in California, then New York, so if you've got people or property again in those states, then New York and California are both likely to say, you've got state tax nexus in our state, therefore you've got to pay income taxes in our state. So that doesn't mean that, let's say your US operations earn 100 of income. That doesn't mean that both states are going to tax that full 100. What it means is they will apportion that 100 between the two states based on your level of activity. So if your New York office was much bigger than your California office, it might be that, well, you pay tax on 75 in New York and 25 in California. So in addition to this people and property nexus, there's also something called economic nexus to just be mindful of. And again, it depends on the states in which you're doing business. But some states will say, if you sell X amount of product or service to people in my state, we're going to say because of that high number that high number of income or sales into our state, you're going to have what we call economic nexus, and therefore you also have a tax liability in that particular state. So again, these rules vary by state. It's just important, again, I keep saying this, to just be mindful of what you're doing when you initially go into the US, so you can keep control and sort of understand what your overall state footprint is likely to be. Okay, next slide. And I'm going to briefly talk about sales and use taxes, because income taxes and sales and use taxes are the two topics that tend to be top of mind for my clients who are, again, expanding into the US for the first time. So what is sales and use tax? Sales and use tax is levied on the end user of a product or service. Sales and use taxes, and again, unfortunately, it's 50 different states, 50 different sets of rules. If a state levies sales and use tax, they almost always levy it on tangible goods. So if you're selling books or some other kind of tangible item into a particular state, on that very last leg of the sale. So if you look at this example, I've got my non-US seller selling to a U.S. subsidiary or a distributor or a retailer who then on-sells to the U.S. customer. It's only that sale to the U.S. customer that is subject to sales tax, versus on the right-hand side, where if you're selling direct to your U.S. customers, it would be that direct sale in which the states would levy sales tax, potentially. Sales tax tends to be levied in the state in which the end user is. So if you were selling a tangible good to customers in California, you could be liable for California sales tax. You don't even necessarily need to be operating in the US. So let's say you were just selling remotely from Kazakhstan or any place outside the US. If you were in this, on the right-hand side, B2C model, and you're selling directly to customers in the US, even if you have no physical presence in the US, no people, no property, the states can still say, if you've got if you've met a certain threshold of sales to customers in my particular state, we can still require you to levy and remit sales tax on those sales, even if you have zero physical presence in our state. So if you're in particular selling tangible goods into the US, I'd strongly urge you to think about sales and use tax and whether or not you could have a collection and remittance requirement now or in future. Next slide. So just very briefly, because I'm at EY's London office, so in Europe, and often get questions about is sales and use tax. That's essentially just VAT, right? It's VAT, but it's not VAT. It's different from VAT in that VAT is charged at the state level rather than the federal level. Or sorry, sales tax is charged at the state level rather than the federal level, like VAT. Always, if a state levies sales tax, they will levy sales tax on tangible goods. Some states will also levy sales tax on services. It's something I'm seeing increasingly if we're dealing with tech companies or software as a service. We're doing a lot of taxability analysis just to see whether or not that might be, that service, that SaaS service might be taxable in a particular state. Very different from VAT. VAT tends to be levied on each chain in the sales cycle, and then you claim it back. Whereas remember, sales and use tax is only levied on the final sale, and it's not something that's claimed back by the seller. And lastly, unlike VAT, there is no central legislation. Again, it's 50 different states, 50 different sets of rules. So each state that you're selling into, you'll need to think about whether or not you might have a sales tax collection and remittance obligation in that particular state. So in summary, this is just kind of the tip of the iceberg that we're talking about here. If you are going to expand your business into the US, I appreciate it sounds quite daunting, just these various levels of taxation, but I'd strongly encourage you to think about how you're going to structure that US investment, that US expansion before you do it, to make sure you can manage everything and you're paying taxes in the right places where you ought to be, and there's no surprises. Great, and thank you very much. Pass it back to you, Vladimir.
Thank you, Gillian. Thank you, Michael. It doesn't seem to me that it is easy to invest or live in the United States, at least from the tax standpoint. However, I do understand that one minimize the damage, having planned or prepared everything in advance. So this was our last presentation for today. I would like to thank all speakers for detailed and important information about investments in the United States. It looks like it is all possible, and there are a lot of resources to help you during this journey. From my side, I can only echo that any cross-border investment has two countries involved at least. While we have to watch carefully on different aspects of the US law when we invest, we actually have to monitor Kazakhstan legislation as well. So we have our own currency control matters, control for incorporation regime, quite specific personal income tax requirements, very similar to the United States, by the way. And one of the strangest requirement is, speaking of US state taxation, US Delaware state is considered offshore territory in Kazakhstan. And this inter alia means if you sell anything registered there, you must pay tax on the gross proceeds, not allowing for a cost basis deduction. Be careful with that. And my closing statement would be, as with any important milestone, especially cross-border, appropriate and advanced planning in both jurisdictions may significantly help and even save costs. Thank you to our participants for the time dedicated to the webinar. We hope you find it interesting and useful. And now it's time for a quick Q&A session, and we will be happy to clarify any questions you have. And I think we have several questions to most of our speakers. Let me check it. So our first question was, a question to Alisa Karala. We are planning to open an export company in the United States as our supplier does not export. Which type of visa needed to attend US next few months? I have been in US in 2014, 5 years, B1, B2 visa. Thank you. Alisa?
Sure, thank you for the question. So in order to take care of activities relating to setting up a business, you can apply for a new B1, B2 visa, which is generally used for business and tourism purposes. This will allow you to take care of things such as applying for business licenses, scouting for property, setting up meetings with suppliers, getting credit, things like that.
Okay, and I think the relevant question regarding immigration is, does the US issue visas now? Tourist, business, non-immigrant? I mean the COVID-19 situation. So what's happening with visas during this pandemic time, I would say, I guess the question is.
Sure, well that's a good question. Currently in Kazakhstan, we restored all routine visa services in December of last year, meaning that we are providing visa services for both non-immigrant and immigrant services. However, as you can imagine, we've accumulated quite a backlog of employment requests, given that we had reduced our operations for such a long period. So it may take several months in order to actually get an appointment to come in for a visa interview.
Okay, and another question to you, I guess, is, do we have minimum threshold of investment for receiving investment visa?
There is a minimum investment threshold for the EB-5 immigrant visa, which is $900,000 US in either a rural area or an area with high unemployment. And for all other areas in the US, the minimum is $1.8 million US. There is no set minimum requirement for an non-immigrant investor visa. The amount of capital that is required is going to depend on what type of business you're planning to open and what the capital requirements will be to successfully operate that business.
All right, thank you. The next question is, I think, to Dean Matlack. We are planning to invest in a company in the United States. The company is already registered by Kazakhstani resident. We will invite investors from Kazakhstan. How to properly arrange the investments? Thus, during the payback period, it will also return to the investor as a return on investment. For example, in Kazakhstan, we do this as a financial assistant from the founder. Could you advise lawyers or anybody else to consult, please?
Hi, Damir. Thank you for that question. Glad to hear that you are interested in investing in the United States. I don't know the particulars of your investments, and I'm not an expert on how to best structure it, but I would hope that you could connect with colleagues here from Ernst & Young, from EY, to potentially address some of your questions. And of course, there are lawyers that we can make connections to, both here in Almaty and in the U.S. So those resources are definitely available, and we'd be happy to to work with you to connect you to the people you need. Thank you.
Yeah, one other quick question to you, Dean, is sponsoring of the USA Select Summit. Do you do anything to kind of sponsor or reimburse some of the costs of visiting this kind of events?
We do not have any funding available for companies to attend, but I will say that, you know, the advantage of this year's summit is that it's virtual and the cost is significantly reduced. And so in a sense, you're getting, you know, all the benefit from the programming without having to travel to the United States. You know, normally this is held in Washington, D.C. So there is a cost associated with it, but it's significantly reduced this year.
Sure, that's true. That's true. Another set of questions to Michael and Gillian. Michael, can I get more information about the taxes on investments from foreign citizens? This is quite a general question. The other question is, what happens with the US tax if the spouse stays in Kazakhstan and does not join me in the United States?
Sure, yeah. So, you know, I think the slides that we went through provide, you know, a good overview on, you know, to address probably a lot of the questions that you might have in that respect. But, and I think the slides are going to be provided to all of the registrants after the webinar. So, you know, you can have a look at it. And if you still have questions, you know, that are more specific, you know, you should feel free to reach out to us directly, and we'll be providing our contact details with the materials as well. So if you have, so with the respect to the second question, so let's say that you move to the U.S. And your spouse stays at home. So that won't impact, so from an income tax residency standpoint, that would not impact, you know, the process of day counting, right? The number of days you spend in the U.S. For determining whether you might be a tax resident, right? But it may impact how we look at some of these more subjective criteria, such as domicile, right? So the question is, are you domiciled in the U.S. for estate and gift tax purposes? If, you know, again, if you're in the U.S. on a temporary basis and your family is in the U.S. and all of your ties remain in the U.S., you know, the facts there point to that maybe you're not domiciled in the U.S. So the fact that your wife remains in Kazakhstan could be, you know, an important factor in that consideration. The same is true for applying tests under you know, tiebreaker residency rules under the treaty, and for determining whether you have a closer connection to Kazakhstan under the closer connection exception to the 183 days of presence rule for U.S. income tax residency. I hope that helps.
All right, thank you. Samal, can you probably switch to the other slide with contact details so people could write them down or make a picture of it just in case? Another question, I think quite similar in the general nature, is to Gillian. Are you able to privately consult by the corporate and investments taxes? So I guess it's just the same. Yes, of course, we can.
And it also, this is another plug for the Select USA. If you have a look at the Select USA website, myself and some other people at EY co-wrote an article on taxes that'll give you a bit more detail around some of those corporate level taxes, including state and local taxes that I spoke about today. So I'd encourage you to have a look at that taxes chapter in the US inbound investment guide on the Select USA website. But again, also please reach out to myself or Michael directly. We'd be happy to have a sort of no obligations initial conversation with anybody today.
Thank you, Gillian. And I guess given that the time is getting over, we will have just the last question, and I think it's addressed to Alisa. If investment made to US public trade stocks, bonds, or ETFs, could it be a basis to apply for E-type investor visa?
Generally not. I think that would be a tough one to apply for an e-investor visa for, because again, one of the components of qualifying for an e-visa is showing that there is a substantial economic benefit to the United States and not just to the individual and his or her family. So I wouldn't be able to make a formal determination outside of a formal visa application, but I don't think that would be an appropriate type of this type of visa.
Okay, thank you very much. All right, so we have to close our webinar. Let me thank you again, our speakers, for raising such an important matter, and our participants for being with us and asking interesting questions. If you still have some questions or will have them later, please do not hesitate to contact any presenter. Contact details you can see here on the slide. So thank you very much and have a nice day ahead.